I'm going to call Mr. Warner's case. It's the People versus Keegan Warner, file 25-7004FH. Got Mr. Warner in the courtroom with his lawyer, Mr. Andriaki, the prosecuting attorney, Ms. Goodrich for the people. We're here for a docket call. Mr. Andriaki, how are we proceeding, sir?
Your Honor, with me entering a plea, if I may.
Would you please stand and as best you can, raise your right hand for me, sir? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
You can be seated. Are you Keegan Ray Warner?
Yes, sir.
Okay, Mr. Warner, a guilty plea hearing is an important event. It includes the waiver of constitutional and other rights that you have. So I want you to listen carefully. At any time, if you have a question, ask me. I'm happy to answer. If you need a minute to talk to your lawyer, you just let me know. We're happy to give you that time. Is that all right?
All right.
Now, I have to advise you of the maximum penalty that you could face for the charges you're offering to plead guilty to today. And that would be counts 3 and 4. Count 3 is using a computer to commit a crime with a maximum of 4 to 10 years of the underlying crime. That is a felony punishable by 7 years and or a $5,000 fine with reimbursement for the costs for government expenses and a discretionary consecutive sentence for the underlying conviction. Count 4 would be the underlying conviction accosting a minor for immoral purposes. That would be a felony punishable by a maximum of 4 years and or a $4,000 fine. There's mandatory AIDS and STD testing. And there's, it would be a tier 2 offense under the Michigan Sex Offender Registration Act, unless you have a prior tier 2 offense conviction, in which case it would be a tier 3 offense. So the discretionary consecutive means that the maximum exposure you would have would be the 7 years plus 4 years or 11 years maximum in the state prison. Mr. Warner, do you understand the maximum penalty allowed by law for those charges?
Yes, Your Honor.
Are you on probation or parole anywhere?
Not currently.
Okay, were you on bond for any other cases at the time of this incident back in October 2024?
No, Your Honor.
Okay, did you read and understand the rights listed on the advice of rights form?
Yes, Your Honor.
And did you sign that form today?
Yes, Your Honor.
Do you have any questions for me or for your lawyer about any of those rights?
No, Your Honor.
Do you understand that if you plead guilty, you'll give up all those trial rights and you won't have a trial of any kind?
Yes, Your Honor.
And is that what you're choosing to do today?
Yes, Your Honor.
All right, if I accept your plea, you're giving up any claim that the plea was caused by any threats or by any promises that are beyond the terms of the agreement. Do you understand that?
Yes, Your Honor.
Also, when you plead guilty, you give up the right to appeal. And if you wanted to appeal, you'd have to seek permission to appeal. You would do so by filing an application. Court of Appeals would not have to hear your appeal at all. If they did decide to hear your appeal, the types of issues that you could raise are very limited after a plea, much more limited than if you were convicted after a trial. Do you understand that?
Yes, Your Honor.
The plea agreement provides that in exchange for your plea of guilty to counts 3 and 4, the prosecutor will dismiss the remaining charges. Do you understand the terms of that plea agreement?
Yes, Your Honor.
Mr. Andriaki, is that a full, fair, and accurate statement of the terms of the agreement?
Yes, Your Honor.
Ms. Goodrich?
Yes.
All right, Mr. Warner, other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No, Your Honor.
Has anybody threatened you in any way to make you do so?
No, Your Honor.
Is entering this plea your own free choosing?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge in count 3, using a computer to commit a crime punishable by at least 4 years?
Guilty.
How do you wish to plead to the charge in count 4, accosting a minor for immoral purposes?
Guilty.
So, Mr. Warner, back on October 1st of last year, 2024, did you have some communications with a person who was located in Cheboygan County?
Yes, Your Honor.
Was that person less than 16 years of age?
Yes, Your Honor.
Did you know that that person was less than 16 years of age?
Yes, Your Honor.
Were you using a computer program or a computer device to communicate with that person?
Yes, Your Honor.
Were you situated in Cheboygan County or no?
No, I'm in Abbott County.
Okay, but the person you were communicating with was in Cheboygan County?
Yes, Your Honor.
And during the course of that communication, did you have some communications of a sexual nature with that person?
Yes, sir.
Did you ask that person to engage in any sexual activity with you?
Some pictures. Yes, sir.
And you asked them to send photographs that would be of a sexual nature
Yes, sir.
of them in an unclothed state?
Yes, sir.
Okay. Mr. Andraki, are you satisfied with that factual basis?
Yes, Your Honor.
Ms. Goodrich?
Yes.
Mr. Andraki, are you aware of any other promises, threats, or inducements?
No, Your Honor.
And do you believe I fully complied with the requirements of MCR 6.302?
I do, Your Honor.
Ms. Goodrich, on both those questions, your thoughts?
Yes.
All right, and Mr. Warner, I find that your plea is knowingly, understandably, and voluntarily made, and that there's a sufficient basis in fact and law to believe that you are guilty of those offenses. So I do accept your plea. You'll have to cooperate with a pre-sentence report where you'll be interviewed by an agent from the Department of Corrections so they can make recommendations about what I should do with you. I would presume you want me to know more about you than what I just learned right now. There's two ways that I learn about that. One is through you and your attorney at the sentencing, and another is through this pre-sentence report where I learn more about who you are. So we'll schedule sentencing for September 30th. Mr. Andriaki, morning or afternoon work better for you?
Afternoon would be best, Your Honor.
How about 3 p.m. okay?
Perfect, Your Honor.
So we'll schedule your sentencing, Mr. Warner, for September 30th at 3 p.m. Anything further from the defense,
No, thank you, Your Honor.
from the people?
No, Your Honor, thank you.
All right, we'll see you then, sir.
Thank you, Your Honor.
Good morning. Can you please unmute yourself and tell me your name?
Can y'all hear me now?
Yep. All right. This is People v. Jessica Laarza, file 25-6983FH. We've got Ms. Laarza zooming in. Her attorney, Mr. Nightingale's in the courtroom, and Ms. Goodrich, are you on the people, or Mr. Juliet, you're on the people on this one?
Yes.
All right. So, Mr. Nightingale, we're here for a docket call. This is in this larceny case. What's our status here?
Judge, I think we just need to get this back on the trial docket whenever the court's able to accommodate us. I don't see a resolution occurring.
Okay. Take down the necessary information to make that happen. All right, the bind over was January this year. Ms. Laarza is not in custody. What would be the estimated length of trial?
2 days, I believe.
All right, I think what I could do is there's only one or two on the list above Ms. Laarza, so I think I could set this for Thursday, Friday, November 6th and 7th. Any objection to those dates from either party?
Judge, can the parties approach potentially on that?
Yes, yes. 2-day trial, Ms. Laarza, on October 2nd and 3rd. And we'll schedule it then for a docket call on September 9th. Oh, you said you have a training that day.
I do.
You've got
That's
a
it.
couple things that day that you'll want to be moving around then.
Yeah, probably, Judge.
All right, we'll set it for docket call on the 30th. If you know prior to then that you know. Well, I mean, I don't know. Do we need a docket call, or do you just want to notice something up if there's a change?
Yeah, I would say let's just not have a docket call and I can notice if there's a resolution.
Okay. Okay, so we'll schedule this for a 2-day trial to begin on Thursday, October 2nd, continue into the 3rd. I'll give you both 14 days to exchange witness and exhibit lists. 7 days prior to the trial. Jury instructions and verdict form will be due. I'm not going to schedule it for a docket call. If there's any motion that needs to be noticed up or any different resolution, the parties can just contact the assignment clerk and even get a special date to get in and take care of it. But otherwise, Ms. Laarza, I'm next going to see you in person in the courtroom on Thursday, October 2nd, for your jury trial, okay?
All right.
Okay, see you then.